What happens if you don't have a power of attorney for healthcare? Who would make healthcare decisions for you during a medical emergency? If you don't have a power of attorney for healthcare and are experiencing a medical emergency in which you lose the capacity to make your own decisions or are unconscious, an Illinois law requires the hospital or medical facility to find someone to make decisions for you. This law is called the Illinois Healthcare Surrogate Act. If you don't have a power of attorney for healthcare in place already, this is the list of people the hospital would have to contact in order to find a substitute or surrogate decision maker. Guardian of the person, spouse, adult son or daughter, either parent, adult brother or sister, grandchild, close friend, guardian of the estate. The order of priority in this list cannot be changed or skipped over. This means spouses have the final say above children, and parents have priority over siblings, if that is the closest relative available. Often, this means that the order of priority would not authorize the people you trust the most to make emergency medical decisions, such as decisions about life support. Why? Because Illinois law does not recognize certain relationships. Common law marriage does not exist in the state of Illinois. Unmarried partners would be considered close friends no matter how long you've been together. This also means that if you are separated from your spouse but never got a divorce, they would still be considered your spouse and have legal authority to make decisions for you if you didn't make someone else your power of attorney agent. After your husband or wife, children are next in line to make decisions. Keep in mind, unadopted, non-biological children are not considered your children under this law, even if you dedicated your life to raising them. You have to name them your power of attorney agent for them to have authority. Foster siblings are also placed in the close friend category unless you name them as your agent. Even if this list reflects exactly the order of people you would want to make decisions for you, there is still a lot of room for confusion. For example, if the decision makers are your siblings, in Illinois, they must first try to reach a decision together. If they cannot reach a consensus or a unanimous decision, then a majority of your siblings will have to agree on what steps the hospital should take. If they are arguing and can't come to an agreement, or if there is no majority decision, the hospital will continue to keep you alive or send your family to guardianship court and ask a judge to appoint a guardian. When you make a power of attorney for healthcare, you can avoid guardianship by appointing someone you trust to make decisions in these situations. This is what a power of attorney for healthcare does. It gives clarity and peace of mind to your loved ones. The Illinois Healthcare Surrogate Act only covers emergency medical treatment decisions or the decision to end life-sustaining treatment. It does not cover medical decisions about non-urgent matters, like seeing a new specialist or entering a memory care clinic. You need a power of attorney for healthcare for that. If you need help with your finances, like paying rent or filing your taxes, or even making decisions about things you own, like your bank accounts or pension plans, your family, your friends, or even the state will have to ask the court for guardianship unless you already have a power of attorney for property. Watch video testimonials from participants of the power of planning and learn why they chose to make their powers of attorney documents. Having your powers of attorney ready during a medical emergency can be one of the most valuable tools your friends and family have so they can respect your wishes and ensure you receive the right care. Make your powers of attorney today and take the power of planning into your hands.